This event is being held in the context of Berghof's 50th anniversary since we first started getting involved in conflict transformation. And I'm incredibly pleased to host this meeting, which I'm doing from Scotland, but the Berghof Foundation is based in Berlin, and of which I hope this will be the first of a series of conversations on this topic. I mean, both human rights and mediation are separately intrinsically important, especially at a time of relative dearth of mediation activities and at a time of global pushback against human rights, which we have been witnessing for the past 15 years as rights and freedoms are steadily chipped away each year. But if they're intrinsically interesting, the intersection is also extremely important, although it's a slightly complex intersection. Generally speaking, those involved, the advocates and practitioners of both human rights and mediation, are supportive of one another and believe that they are fundamentally pushing for the same goals, which indeed they are. But in practice, however, sometimes those engaged in mediation and those engaged in human rights sometimes see themselves working slightly at cross purposes. And sometimes they caricature one another's positions. And at the risk of simplifying, because by definition, all caricatures are simplifications, I'd say, having been part of both fields of activity, I would put it in roughly similar, I would put it in along these lines. Mediators are sometimes seen by human rights activists as political above all, which means sometimes that they are seen as being determined to work for a political deal, a fix-all deal, at the expense of principles, at the expense of human rights, and at the expense of sort of equality of participants. And that they are sometimes too ready to gloss over the massive human rights violations that are often a key factor behind the conflict. To which and therefore they don't push accountability in the way that human rights activists would wish. Conversely, mediators might say in response, well, yeah, we basically plead guilty to much of that because we believe that peace is, in fact, the fundamental, or living in peace is fundamentally the human right upon which all the others depend. And they would say that, look, you human rights activists, with your sermons, your megaphones, and your constant naming and shaming of parties to a conflict, which can actually show lack of political savviness and also undermine our mediation work. So can you please go and take your moralizing somewhere else? So, but like most caricatures, there is something in both of those, but also a great deal lacking. And I would say two things in particular are lacking from those caricatures. One is the relatively new concept of a sustainable peace, as opposed to just like a sort of quick political fix, which means that peace has to be based on human rights and the resolution of social grievances that so often lie at the base of the cause of conflict. And the second thing is that human rights, its theories, its practices, and its applicability are a lot more than what many people, including mediators, sometimes think it is, which is just naming and shaming and calling out human rights violators. And that actually there's a lot to human rights that can be usefully integrated into mediation processes and therefore make a sustainable peace more likely. So I'm absolutely delighted to have with me today three absolute world experts on the topic. And we have Asif Khan, who is the head of the Mediation Support Unit of the United Nations Department of Political and Peacebuilding Affairs. We have Alvaro de Soto, one of the most important mediators in the UN over the last 40 years. And then to start us off, we have Ilze Kehris, who's the UN Assistant Secretary General for Human Rights. So with that, Ilze, would you start us off, please?
Thank you so much, Andrew. It is really, I'm so delighted to be here. It's such an important discussion to have, and you are the perfect person to bring us together with your present hat and your former hat, indeed, as the Assistant Secretary General for Human Rights yourself. and therefore having seen those caricatures in a sense in real life. And I fully agree on that. And plus, of course, the context that we now have, and the colleagues on the panel will address this, no doubt, on the whole conflicts becoming more and more multifaceted. I don't know how many facets we will have on this. It's not a diamond, unfortunately, but the complexity increases, and of course polarization as well. So all the more important to bring together these two communities that all too rarely really speak or draw on each other's experience for the benefit of the actual cases. We all know that the UN, or certainly that the UN has a lot of experience both in designing and facilitating peace agreements. Asif is here who can testify to that, but so can the rest of you. But obviously we do have mixed results. So the first thing is to be honest and learn the lessons that we learn. Some laid the foundation for long-term peace, and others, of course, have had both ambiguous or disputed outcomes. So we need to learn those lessons. And here the question, of course, is also focusing on whether and how human rights can really help to make the peacemaking efforts more effective. And you mentioned already the intrinsic link between human rights and conflict. I think this is something that we often turn to. And the root causes, of course, of conflict very much relating in most cases to human rights violations. But very often human rights are still seen as a hindrance to mediation and peace negotiation efforts. Perhaps really because they're perceived to constrain, to interfere with that political pragmatism and political savvy, as you mentioned, that is needed to bring the parties of conflict together and to really address the issues effectively. So I really hope that we're looking at this human rights role that it can play in both the formal and non-formal peace processes, so we can show together and look at examples also where human rights can really form not only the basis of an agreement to end the conflict, but also shape and inform better mediation and negotiation processes themselves. We know, again, that the causes and consequences of conflicts have to do with human rights in the peacemaking context. We really look at the development of the whole modern human rights system as such. Either the documents that are aimed at ending and preventing conflict or blueprints for post-conflict settlement really have this human rights dimension inherently in them. Most notably, of course, the charter itself, that combined, we have the Article 1, Paragraph 1, outlining the first purpose of the organization being to bring about by peaceful means and in conformity with the principles of justice and international law, adjustment and settlement of international disputes or situations which may lead to a breach of the peace. So here we see that human rights are obviously part and parcel, fully integrated of the process to find a solution already with this. The Charter gives us the mandate, as it were, and certainly the responsibility to do that. And there, the peace agreements have the fundamental purpose of ending human rights violations, as you said, Andrew. Finally, the violence, right to life, of course, itself being very fundamental, the human right. So, and again, all of us know that peace is not just a mere absence of violence, and this is that whole vision of a positive peace at the basis of the UN's agenda, including the prevention agenda. We create the foundations for durable peace. You mentioned the sustainability as one of the factors we need to look at, to really avoid both the recurrence of violence, but to build that positive peace that really has sustainable investments in economic and social development, as well as the whole rule of law, institutions, and inclusive participation that really addresses the societal divides. So the full spectrum of civil, cultural, economic, political, and social rights respond to that kind of positive vision of peace. So that's why we believe that we really need to have a holistic understanding of human rights in mediation. And that can help mediators in the task of both identifying the political solutions for the parties to the conflict, and also very importantly, it goes beyond the legal accountability, as you mentioned, that is often seen as an obstacle, and that often dominates what mediators think of as the human rights, and therefore necessarily brings some hesitancy to embracing it, but to include really the full range of rights that really address the real needs of real people, so including in the areas of social and economic rights. And that really, we believe, should have greater space in the mediation processes themselves. We have the Pathways for Peace. You know very well the study published by the UN and the World Bank already in 2018. And there we had 4 factors driving violent conflict emphasized: unaddressed grievances, inequalities, exclusion, and a lack of participation in decision-making. And clearly that very much relates to the basic accountability principle in a broader sense, not just judicial, but also the responsive and accountable governance, equality, non-discrimination, inclusion, of course, and participation. So there, contrary to that perceived tension between human rights and the process of peacemaking that you also referred to, Andrew, the argument can be made, I believe, very clearly that human rights are central to the peace process and indeed even indispensable. So instead of exclusively focusing on immediate security concerns, human rights information and analysis based on this can really help to promote a comprehensive process that addresses not only the direct violence, but also structural violence by including that focus on social justice, political equality, and accountability for past wrongdoings as well, in order to forge a way forward. So in that sense, the 2 processes really are intrinsically linked. They can reinforce each other mutually if properly understood at all stages of the peace processes. Colombia is an example of how the full spectrum of human rights permeated the peace negotiation, especially regarding the economic, social, and cultural rights, helping to ensure that the final agreement addressed the grievances of the whole population, importantly, not just the political actors themselves, which is another dimension of concern that we, of course, have in these processes. The agreements were inextricably linked to human rights and justice. They recognized respect for human rights as a goal that must be promoted by the state, establishing also that economic development with social justice in harmony with the environment will guarantee peace and progress, and social development with equity and well-being for all will allow the country to grow. So again, all the linkages can clearly be seen there. Critically, the government of Colombia and FARC-EP agreed at the very outset of the negotiations in 2012 to place victims and their human rights at the heart of the peace process. So the victims' direct participation in the Havana peace talks, that's something new that had never occurred before in other peace processes, is said to have a direct impact on the peace agreement's comprehensive transitional justice system, which recognizes the importance of addressing the grievances of victims as the building block for sustaining peace. Accountability, transitional justice are perhaps where peacemaking most traditionally and also readily embraces human rights as the subject matter of an agreement. Transitional justice is a human rights-based policy instrument which seeks to build peace by examining and addressing past human rights violations, their causes and their consequences, with a view, of course, of overcoming divisions, healing traumas, and preventing future violations as well. These are difficult, but necessary processes. I recently had made a visit, a mission, as we call them, I don't know why, but a visit to South Sudan last month. And there, I really could see this also at play right now. More than 3 years after the signing of the revitalized peace agreement, the full implementation of the transitional justice mechanisms that were agreed is still outstanding. Those were 3 parts: the hybrid court for South Sudan, a commission of truth, reconciliation, and healing, and a compensation and reparation authority conceived as a full whole with the 3 parts of it. So there have been recently launched, and I welcomed that with the authorities, the launch of national consultations for the establishment of the Commission for Truth, Reconciliation, and Healing, Although we should say also in the very challenging environment where there are increasing restrictions on civic space. So the reminder there also to the authorities, I took the opportunity to say to really make sure that that is an inclusive and meaningful process. Otherwise, there is no point. But there's somewhat more of a reluctance and certainly no steps taken yet, for instance, for the hybrid court. So there again, we see, and the message I was giving is the importance of really making sure that this full package of transitional justice is taken on. But still, indeed, as you were saying, human rights are often seen as an obstacle to peace processes. And that is really often more a general perception maybe of human rights as being confrontational, as you're saying, but just not only norm-based, but actually moralizing and very technical, legalistic, and insufficiently related to a tough reality of politically very challenging situations. And I will be the first one to acknowledge that I do think that we in the human rights community actually also need to listen to that criticism. And often we don't do ourselves a favor where we can project this kind of finger pointing and moralizing attitude, and of course be perceived therefore as absolutist and not necessarily the partners you want in a very complex environment. So that's why with this agenda and the complexity of it, as you pointed to, Andrew, I think it really requires, and we have to admit that it requires that adjustment and the effort on both sides to come together, to really learn from each other, to really listen, to have the openness to learning and understanding so that we can jointly and also based on the context really analyze the challenges and identify where human rights can contribute to the society's own roadmap, to be stressed as well, of course, not coming from outside, towards stability and peace. So here I think we have the opportunity now, and I really look forward to the panelists, and certainly the UN can learn from Berghof Foundation, from other organizations involved and experts engaged in this, as well as I should mention some regional organizations that have experienced in a human rights-based approach to mediation or conflict prevention, as some do. I know I shouldn't be using up a lot more time, so I just want to very quickly outline and maybe come back if there is time at the end, that I think that the human rights approaches and outputs really could be useful to mediators, we believe, in at least the following ways. Number one, human rights provide an alternative and more neutral language and framework that can move narratives away from denunciatory, accusatory language because they are based on universally accepted norms, while also promoting that common understanding of relevant issues of the grievances by all parties. This is to some maybe counterintuitive, but this I think is a very important point. And actually also looking at the guidance to how states can actually fulfill their obligations. I had an example there on Mati Atisari in Aceh, but but at the same, I think I'm running out of time, so maybe I will go in there. But the whole point there is also that really human rights were placed as part and also and in looking for a solution, as well as a Commission for Truth and Reconciliation that was proposed in the negotiations. With his warning very much in Jakarta to the leadership, both political and military, that if violations really continued unaddressed, then peace would come to nothing. So really that very strong message. Secondly, human rights monitoring can build confidence and bring people to the table because it presents an objective, unbiased representation of events, even if there have been very polarized narratives around it. The objective facts and all of this, we again have examples from Colombia, a very important example with the parties brought to the table in Havana, and where victims were participating as well, and really having that framework for interaction. Third, human rights can be a framework for dialogue. This again is not immediately evident to all mediators, but very much providing a safe space for discussing prevention issues, because there is again that universally agreed legal standards of what a state can and cannot do vis-a-vis the individuals under its jurisdiction, and that is a very obvious contribution as well. El Salvador, of course, being a case in point, since we have Alvaro de Soto here, I will certainly not dare to go into the example as such, but clearly he provided a very important example himself on his own initiative at an impasse in the negotiations, which really were based on several agreements, but the first one, of course, also really the essence of human rights. So I look forward to hearing more from you, Alvaro. Fourth, and finally, the human rights actors really have granular information, the gathering of information on the ground. They have valuable networks of local and national actors, and they're often already in place before mediators and mediations begin, before mediators get there. We have, as OHCHR, over 100 presences across the world. We also work with national human rights institutions who themselves have networks of civil society actors, organizations, as well as community leaders and so on. So this can really be tapped into and certainly serve to help and coordinate with mediators. And I think that you are pointing to me that I should be ending now, so I will do so. But I'm just very happy as well that we have the cooperation that we have with Asif and with his mediation support unit in DPPA, I think is exactly, and this is where we're deepening the kind of cooperation and common understanding as well, because I think even internally within the UN, we have this work to do that can support this, but certainly looking forward to all of the inputs from you and the discussion as we go ahead from here. So thank you very much.
Well, thank you very much, Ilze. And I wasn't pointing at you, I was just holding my pen. And anyway, but thank you so much for laying out so many different ways in which human rights can indeed contribute to to mediation. And it would be very great if we can build up on this. Alvaro de Soto, you have, I won't embarrass you by going through it, but an incredibly distinguished CV, most recently as Peruvian Ambassador to Paris. But for many decades, and it was my privilege to work with you for several of those at the UN, and you headed the UN's political work in the Middle East, in Cyprus and West Sahara, and many other places in Latin America. But I think actually especially relevant for us today, and I understand that you're actually in Madrid for the 30th anniversary of the El Salvador Accord, which you were the key person in. And we were hoping, particularly since, as I understand, I was a very young junior officer at the time working in Afghanistan when you pulled that off, but I didn't follow it carefully, but it was held up as a great UN achievement at a time when there were several achievements just after the end of the Cold War, and then there was an excitement that the UN was going to play a great role in ending many disputes, which was partly true, but just not as many as we would have liked. But you were known as particularly involving human rights into your mediation, and I would love it if you would kind of tell us a little bit about that.
Well, El Salvador was almost designed for human rights to be woven into whatever peace agreement emerged, because it was very much in the sights of the human rights community at the time, and there'd been a special rapporteur of the Human Rights Commission for any number of years, and with good reason. They were major violators, particularly during the conflict that began on or about 1980, but had been preceded by systematic human rights violations by the army and by death squads, which operated with the protection of the army. And therefore, the situation was such that the FMLN was able to make the case, and they went to Geneva and made quite a show of signing on to Common Article 3 of the Human Rights Covenants, and thus focused attention to it. So they made a political use, fully justifiable, but they made a political use in their war efforts and in getting voluntary contributions, which were a very large portion of the funds that they received to operate. And when it came time for negotiations, therefore, they had created a situation where they developed enough strength to pretty much force force the government to come to the negotiating table. The people who supported the recently elected president, whose party, by the way, had a pretty awful record itself, because the founder of the party, and before him, the leader of the party, was none other than the chap who gave the order for the assassination of Archbishop Romero, today Saint Oscar Romero. He got a lot of pressure because he was not able to mobilize the economy, which was his vocation as a businessman. He was not able to get it moving again because the wealthy classes in El Salvador would not invest in El Salvador because of the risks that they were put under by the guerrillas. So when negotiations finally came about, it was pretty much the guerrillas, the FMLN, which set the agenda. And at the top of their agenda was, we have to fix the human rights problem. And their starting point was abolish the armed forces. But short of that, which they knew that they weren't going to be able to get, they insisted on a number of reforms: a large reduction of the army, the elimination of elite battalions, most of whose officers, by the way, were trained at the notorious or the infamous America's College somewhere in Georgia in the US, not the Caucasus, Georgia, but the US, Georgia. And I don't know whether they were deliberately taught the techniques that they were used, but it was pure counterinsurgency, right? Drain the water out of the sea in which the guerrillas thrive. But they committed horrendous massacres as well. So they said, unless we can fix this problem, there's no point in turning to the other items on the agenda, which were on the agenda because they put them there, which included human rights, the judiciary, the electoral system, economic and social questions, constitutional reforms, leaving only a ceasefire to the end, only if they got political commitments on all the preceding list. So they were able to get in the negotiations the dismantling of the elite battalions, the removal by constitutional reform, a constitution which had never been reformed in accordance with the rules of the Constitution in their long history of constitutions in El Salvador, elimination of the armed forces' inherent duty, which they had there, for the maintenance of internal order. So they had both police functions and army functions, and we know what the contradictions between the two are. In those times, traffic policemen in El Salvador wore camouflage uniforms and carried the same heavy weapons that the people who did the killing carried, that kind of thing, which made the traffic perhaps a little bit more disciplined than it might otherwise have been. But in any case, they also they got an agreement for the creation of an national civilian police and for the creation of a public security academy, but also reforms of the military itself, including a purge of the senior leadership of the armed forces. They removed over 100 officers of rank of major, colonel, and general, several colonels also. But they imposed also on, they negotiated with the government a new doctrine, moving away from counterinsurgency. And essentially it became an an armed forces for a democratic, for the operation of an army in a democracy. They were allowed. There was a safeguard clause that in emergencies they could be called on to assist the police in the maintenance of internal public order, but only for defined periods of time and approved by the legislature. Against, I'm not talking about compliance because it has not been complied since. But so you could argue that that and the creation of a national ombudsman for human rights, which they had never had before, which actually took over from what the UN had done as part of its monitoring of compliance with agreements, which was nationwide, long-term monitoring of respect for the clauses of the Human Rights Agreement of 1990. It had never been done before. This emerged after a sort of brainstorming session that we held in Geneva, to which the Human Rights Center, as it was then, as pre-High Commissioner, participated and said, when the idea of nationwide long-term monitoring came up, that the center would have nothing to do with this, by the way. So we had to set it up from scratch out of headquarters. Iqbal Riza was put in charge of this by the Secretary General. You could argue that these and other agreements constituted a sort of scaffolding for the protection and respect of human rights in the entire country. And I think that that would not be far off the mark, not really an exaggeration. But as I said, it had to be done this way. There was no other way to do that. I think that the greatest achievements of the peace accords, besides ending the war, were number one, creating this scaffolding, and number two, opening up political space in a country where any dissent with whatever the mainstream thinking was punished by repression, essentially. And there was political exclusion. And where the armed forces, which was seen by the landed classes as their Praetorian guard, had become a power unto themselves. And there was an article in the Constitution under which they were given the responsibility of ensuring respect for the Constitution unto themselves, not under any civilian authority, and which they used so as to become the ultimate arbiter of political life. Now, let me branch off into something that you may want to anticipate, Andrew, just to answer your question, to anticipate your question. Toward the end of the negotiation, I was approached by one of the parties saying that the other party was a bit concerned that they might be found responsible for a number of things, and that their entire leadership might fall victim to prosecution for human rights violations. And they asked, what would the UN's reaction be? And I said, if you come with something like that, we can't prevent you from doing it, of course. All of this is consensual. But if you did something like that, we would probably walk away. And the reason I mention this is that this is what inspired me. And what I did was, post facto, blessed by the legal counsel, the head of political department, the head of the DPKO, the Secretary General himself. Under Mr. Boutros-Ghali, I wasn't encouraged to follow up on this, but Kofi Annan authorized me to look into the question of what a UN mediator does when faced with a situation such as that. And it is out of that that emerged the Secretary General's guidelines, under which an envoy of the Secretary General, if he learns of something like this in the offing, is to tell the parties that the UN cannot be associated with any amnesties that would exempt from prosecution war crimes, crimes against humanity, or genocide. But I have other points that I won't make, some of them because of what Ilze says, but I don't want to exceed my time.
I was on mute. We will hopefully come back to some of that, but that was incredibly interesting. Thank you so much. And what you said about Kofi Annan's guidelines is quite similar to Ban Ki-moon's, his successor's Human Rights Up Front initiative. Asif Khan, you are head of the UN's Mediation Support Unit, and unlike many UN titles, that actually does explain rather well what it is you do. Could you perhaps tell us whether you see, from your vantage point of providing support to all the UN's mediation processes, whether you see a growing role for human rights at the moment? Is this the trend, or how is it going in your view?
Thank you, Andrew, and thanks for inviting me to join this illustrious panel. I'm obviously a huge admirer of Mr. de Soto, so it was really interesting to hear about El Salvador and the case itself. I think I agree with pretty much everything that's been said, but especially I want to focus in and pick up from where Ilze left it, because it's based on the growing collaboration between our respective offices out. So I'll try not to repeat too much what's already been said, but I wanted to start off by saying that, you know, one depressing statistic, which I think most people do know, is that roughly about somewhere around 2/3, give and take, of peace processes or peace agreements, that are signed, break down with a relapse into conflict just only a few years later. We also know that by now that those that do endure do so because the process leading up to the agreement was inclusive. So we obviously, this is in the context of women's participation, but I think it also applies to other groups. We also believe that those processes and those agreements that adhere more to normative agendas and issues of justice are more sustainable. They have human rights at their core. So our approach is now informed not only by pragmatism and the belief that the mediator's principal job, more than anything else, is to end the war, but also that a process that is more inclusive, that is more driven by norms, is a better process and will get us a more sustainable deal. So there's a political case for doing this, and not only an idealistic one. And that's really what the change that has happened is due to. It doesn't mean that across the board, and I think some of you identify that, but across the board that everyone believes that. But certainly we are more of the view that we need to stress human rights in this work. But it is, of course, up to us to make sure that we sell this to the various mediators who are working in the field and various mediation teams. So at MSU, at Mediation Support Unit, we are continually looking for ways to, improve the likelihood of success of the UN, of the SG's good offices efforts and mediation engagements. We want to make sure that our mediators are equipped with a good or better understanding of the opportunities that human rights can offer in a process. So really echoing the things that were said before. So towards this end, we think that it's important to accurately try and understand the dynamics and the issues at the play at the intersection of human rights and mediation. So, you know, a lot has been said about the tensions between the work of human rights actors or those on the peacemaking side. Yes, there are different worlds, but there's also quite a lot of room for collaboration, and that's really the angle we want to take, rather than, you know, really stressing the positive. What is needed now is to really methodically identify when and how human rights have been used to open space for peacemaking, to improve the quality of good offices and mediation, and to strengthen conflict parties' commitment to reconciliation. So Ilze mentioned a few cases on how human rights can provide an alternative language, how it can make deep contributions to dialogue. All of these things, I think these various aspects are the ones that we're looking at. And we're very happy to be working with the Office of the High Commissioner of Human Rights in this growing project. So our work is all practice-based. I mean, we try to avoid giving generic advice to mediators that, you know, they should be doing this or they should be doing that. We really try and see what experiences are in the field by various mediators. We try and look at lessons, and we try and look at how they have basically implanted certain ideas in their processes. So we've, as part of this project, we've informally convened experts from both communities to identify some of the most sort of salient issues. And we are going to be conducting a whole range of interviews with a number of different actors with some pertinent questions. And we'll be working in the coming months to really try and deepen our understanding on some of this. In due course, we will use these lessons to, as I said, to really try and sensitize our mediators and the mediation teams, but also our human rights colleagues, because I think it's very much it's a two-way process. All of this will be, like I said, evidence-based and based on the lessons from those processes where human rights have been used. I see several possible outcomes of this effort. The first one is quite an obvious one, which is that we would like there to be better coherence, coordination, and complementarity between UN mediation teams, but also the human rights teams. Second, a better integration of human rights analysis in mediation efforts. So in practical terms, what that means is that when mediators are engaging in what we like to call process design, in effect designing processes, that they take into account human rights dynamics and challenges. It's an obvious thing to say, but obviously quite often it doesn't happen. So to give an example, if you look at certain transitional contexts where countries are emerging from autocratic rule or less than democratic rule, or if they're preparing to hold elections, or if they're trying to establish new institutions, there are certain decisions that are quite sensitive and political that should be informed by a human rights analysis. So for instance, decisions on the vetting of long-serving bureaucrats, as we saw in Iraq after Saddam Hussein, or we saw more recently in post-regime Sudan, or in the design of, for instance, of electoral rules about who is allowed to run for office, as has been seen recently in Libya. So there are practical consequences for some of these things. Third, new tools for mediators to build common ground amongst conflict parties. So Colombia was mentioned before, so I won't go into any detail on that, but clearly there it provided a common vocabulary for the parties, and which involve both civil society but also the courts. Fourth, greater attention to inclusion. So not just on what we talk about in terms of women or minority groups and others, but also those parties who are able to influence a given human rights situation or who are affected by it. So, for instance, victims in a conflict. Fifth, increased possibilities of mainstreaming human rights considerations in peace negotiations. So we can accurately address, for instance, again, victims' interests and try and deal with the past. I want to mention the example here of Afghanistan, not because it's a great example, because of course ultimately we failed, but during that process we were able to deploy a transitional justice expert from our standby team to advise the Afghan Independent Human Rights Commission. just to help it figure out how it could position itself as an independent institution in relation to the negotiations that were going on in Doha. So this is really coming at it from a process point of view rather than the fact that we ultimately failed in that process. Andrew, you mentioned that the current geopolitical context is extremely difficult and seems to be getting worse rather than better. We see that impacting across the board all of the different sort of mediation processes, regardless of whether they're UN-led or led by others or those that we support. This could, of course, be an argument for trying to limit the scope of doing this work because it will just make everyone's life more complicated. But we like to believe that I think that consistently we have to continue, in fact, expanding this range and expanding the subject in mediation processes and in the way we provide advice to our envoys and mediation teams around the world. I'll stop there. Thank you.
Thank you so much, Asif. Again, very nice, concise, crisp state of the art there. Ilze, I was wondering if I could follow up on one area. You said you'd just come back from South Sudan, which is a country a number of us are very interested in. Now, there we have the head of the UN is a strong human rights advocate, a long history involved in the anti-apartheid struggle of his own country, South Africa, but in many other places too. Of course, as a non-serving official, I can say things you can't. But South Sudan has always, for me, been, in some case, the example of why you need sustainable peace, because there you have two warlords who, after independence in 2011, basically decided that it was better to destroy the country than to work together. And they have just ripped it apart. And it seems that a peace agreement that just between two warlords is never going to be truly sustainable. And that's why one has to go for a much broader set of issues and far more characters involved than just them. I was wondering if you have any additional comments. And I'm not so much speaking about accountability, although and the hybrid court, which of course is essential, but for other tools that the human rights community could provide to bring peace to it. Do you have any ideas on that based on your recent trip?
Thank you. Yeah, I really do think, and as you know, really going and engaging, first of all, that is a tool in itself. I think, even though, we're not missionaries, so I have the problem with the word mission, but really going and engaging in dialogue with all actors on the ground, I think is really a tool and is quite essential. So yes, apart from the outline that you made, and of course the disagreements that continue and the fractured state of, even any country that has one president and 4 vice presidents, I guess it's sort of already the political structure shows that obviously unity is still far from being had. And of course the violence is ongoing, and you have the different pockets of violence that mixes in, as we know, with all of the other challenges in that multifaceted way we just mentioned. So not to go there, but just to talk about what I think that we as the UN maybe can do, or that we can do better, even if we're trying to do it. One of the things is, and I do think you mentioned human rights up front, and I do think that now, and not just as a parrot repeating because we have the words, but there is the Secretary General's call to action for human rights. I think the importance of that, which includes, of course, human rights up front. So building on those initiatives to make sure that we really leverage that so that all of the UN comes in with a coherent voice. We don't have the same voice. We have different mandates and different parts of the different entities, but it's not just up to the human rights people to raise human rights issues is the main point. So I think that that's one thing that we need to, versus the sort of division of labor, because you mentioned the SRSG in South Sudan, who of course is very committed, but even with his commitment and fundamental understanding of human rights, he cannot of course be the human rights actor driving only a human rights agenda with the authorities or from the mission's perspective. He certainly can do his share in it, but there is still the division of labor issue. But the division of labor, therefore, not necessarily with a common voice, but with a coherent voice, where we understand that we bring those principles of human rights, first of all. Second of all, I think is really having human rights as the solution to problems. You know, instead of going away from the narrative of that moralizing part of it, we do have the legal obligations. It's always a good reminder, of course, to the authorities that they have the obligation to implement those, but also showing and maybe bringing examples or bringing the argument when we have the dialogue that it actually brings solutions, including in the trust building that they need, regardless of the level of oppression of a regime. And I was mentioning the restricted civil society, of course, also not going in the right direction. But ultimately, and certainly either for the peace agreement to be able to finally be implemented, but anything that follows afterwards, of course, the need of a support of the population is there. And of course, not committing violations, but building protection is obviously a key way of doing this. So I think that one of the key things for me as well on those visits is that we, from the human rights perspective, also see that it's not our natural interlocutors are not only the justice ministers or the national human rights institutions and those sort of that have human rights already as part and parcel of their portfolios, but those that we really need to reach out to, and in this case in particular and some others, the defense ministers, for instance, or the top leaders, but dealing with that security perspective, entering into the peace and security field and showing what human rights really can contribute to them, in them being able to govern the country, which of course means also to be able to provide for the population, and certainly by stopping violations that the population is exposed to. So I think that there are all of those that we need to work together on doing, but also, again, us as human rights actors to see that we can be credible interlocutors and enter into a dialogue that doesn't come there just to hit them over the head and saying, which we partly still do, that that they're not compliant, but showing how, for instance, also making sure that the security forces are compliant, that we enter into the whole security sector reform area with our perspective, not against others, but complementing the perspective of others. And I think that's something we need to continue to develop, but that certainly we can get interlocutors that listen to us if we're able to formulate the arguments in a way that makes sense to them.
Thank you very much, Ilze. We have a question from the audience. What are examples of human rights not being taken into consideration during a peace process? Probably easier for a non-UN official serving official to answer that. I can give two very, very quick answers. One is the peace negotiations done by the Trump administration on Afghanistan in 2019 and 2020 in Doha between the government of Afghanistan and the Taliban. I think we can safely say that human rights wasn't remotely on the table from the Americans there. They just wanted an American withdrawal. And a second example I would use for that would be the so-called Abraham Accords between a number of Arab states and Israel, where again, the human rights of the Palestinians were not exactly a factor. Alvaro, I don't know if you can think of any, but I have a question also for you, Alvaro, another one posed. And I think, because I know you regularly meet in one of your capacities with the chief prosecutor of the International Criminal Court. And I was wondering if you would have something to say about the intersection between peacemaking and it's a branch of human rights, the promotion of justice, and what problems might arise from that.
Well, I'm on the advisory board of the Dialogue Advisory Group, which whose flagship event consists of an annual conference. We just a few weeks ago had the latest one, and one of the items on the agenda, in fact, sort of the centerpiece of that flagship event, is a discussion of the problems that arise at the intersection between peacemaking and the search for justice. And in grilling the chief prosecutor of the ICC, which is a sort of the featured event every year for an hour and a half, starting with Moreno Campo, with Fatou Bensouda, and most recently with Karim Khan. That discussion comes up. We still don't know really how Karim Khan is going to end up on this. But if you look at the article, the thinking of the chief prosecutor from the start, and of the tribunal itself, by the ICC itself, from the start, the possibility for a useful and productive dialogue to try to sort out the problems that sometimes arise or can arise at the intersection is very, very narrow because of the court's interpretation of the interests of justice clause in the Rome Statute, where at most, if these two, at most, if a problem arises that could, if there is a premature or ill-timed or ill-conceived indictment of somebody with whom you absolutely have to cut a deal in order to make peace, would be possibly pulverized or very much complicated, because what it provides for is that at the request of the Security Council, which doesn't do the peacemaking itself, of course, rather it's the Secretary General or some other peacemaker, at the request of the Security Council, through a resolution under Chapter 7, that is the only circumstance under which the ICC will put off for a renewable year the indictment of somebody whose indictment they are considering. So it's clear to me that there was no one who had ever come close to a peacemaking effort participating in the drafting of the Rome Statute. And because otherwise, what one could have told them, and it was Hans Corell by the UN or someone else from OLA, splendid jurist, no quarrels about that. But any mediator, or at least a UN peacemaker, would have said, give yourself more latitude, and what you should do is quietly consult, reach your own judgment, but quietly consult with the Secretary General or his envoy. Rather, coming up with a Security Council resolution is just a ridiculous remedy for that. And now this is an issue because there has been, since the global war on terror was declared with great fanfare by President George W. Bush, a proliferation of labeling of sometimes important actors, not necessarily in conflict, but in situations that can redound and end up in conflict, and putting them, declaring them, labeling them as terrorists. And it has become very difficult to talk to terrorists or anyone who has been labeled as such, justly or unjustly, on which, by the way, there are no acceptable, no agreed criteria. Andrew, you are familiar with the difficulties that I encountered myself when I was the special coordinator for the Middle East peace process, something on which you, Asif, have also worked, which is that it's very difficult, and in my time, it was totally off limits for the UN person to talk to Hamas, and which has clearly shown its ability to stop carrying out such acts, and even accepting the principle of creating a state in the area assigned to the Arabs in the armistice agreements of 1948 or 49, and has also is also at least has a foot in the framework of Oslo, having agreed to participate in elections, which this is used as an excuse by Israel to say that they can't talk to Hamas, without whom the idea of Israeli-Palestinian peace is simply unthinkable. And there are a number of other examples. Every authoritarian leader has his own pet political opponent who he is ruled out negotiating with under that excuse.
I absolutely agree, and as you say, I do remember that. And it wasn't just the Americans put pressure on the EU, and the EU put pressure on the UN to go along with that. So for all these years since 2006, after what Jimmy Carter described as the freest elections ever held in the Middle East and in the Arab world, it hasn't been possible to talk to Hamas. Anyway, most meetings are too long. This one is unfortunately too short, actually, but it's the first one, and we're going to continue this dialogue because it really is an important topic and a relatively underexplored one. And I'm really happy that both DPPA and OHCHR are working on this, and so are we, Berghof Foundation, with you both. And I'm very much hoping we will take this agenda forward. Thank you so much, the three of you, and thank you everybody who listened in.
Thank you.
Take care.
Good to see all of you. Thanks.